Yes, this is great news for those of us that have good safety ratings. All right, if you're in trucking, whether you're a carrier, a shipper, or a manufacturing company moving product, you need to hear this because the US Supreme Court just made a ruling that is going to shake up the freight industry in a big way, and most people haven't fully figured out what it actually means for them yet. So let's break it down in plain, simple English. Back in 2017, a truck driver named Yasnil Varela Moena was rolling through Illinois, hauling a load of plastic pots. He was driving a Mack truck for a carrier called Carib Transport. Now here's the thing, Carib Transport already had a conditional safety rating from the federal government. That's basically the government's way of saying we have concerns about this company. They had red flags in driver qualifications, hours of service, vehicle maintenance, crash rates. Multiple warning signs. But a freight broker, C.H. Robinson, the biggest freight broker in the entire country, hired them anyways to move the load. So the driver steers off the road, slams into a tractor trailer that was stopped on the side of the highway. The guy in the stopped truck, Shawn Montgomery, had his legs amputated. He was permanently injured. His life was changed forever. Shawn Montgomery sued everybody, the driver, the carrier, and C.H. Robinson. His argument about C.H. Robinson was simple. You knew this carrier had safety problems. You hired them anyways. I'm gonna hold you responsible. That's on you. C.H. Robinson's argument was, hey, we're just a freight broker. The federal government regulates carriers. That's not our job. The argument worked in the lower courts. C.H. Robinson won. But Montgomery kept fighting, and it went all the way up to the top, the United States Supreme Court. On May 14th, 2026, all 9 Supreme Court justices, 9-0, unanimously ruled against C.H. Robinson. The court said that when it comes to safety, brokers cannot hide behind federal law to avoid being sued in state court. The safety exception is real. If a freight broker hires a carrier with known problems and someone gets hurt, that broker can be held legally responsible. The opinion was written by Justice Amy Coney Barrett. Even Justice Kavanaugh, who sided with the majority, wrote separately to say this ruling could create a wave of lawsuits and drive up costs across the entire industry. So even the justices who agreed with the outcome acknowledged this is going to have consequences, and they're absolutely right. So what does this actually mean going forward? Well, first, brokers are now on the hook in a way that they never were before. Every state in the country now has the ability to hold a broker liable if they put a dangerous carrier on the road. That means more lawsuits, means more legal costs, more insurance costs, and a lot more smaller brokers might not be able to survive that kind of financial pressure. Now here's a free tip for all of you freight brokers out there. There is a technology out there that connects your load board to the FMCSA. So before you hire a carrier, double check their safety ratings. Simple and free. And if you want to watch me do it, check out the link below where I sell loads with a free technology for freight brokers called BlowConnect. Now, industry leaders are already saying some smaller brokers are going to get priced out of the market entirely because they won't be able to afford the insurance coverage needed to protect themselves from one big claim. We're talking potentially $5 to $10 million coverage for a single incident. Second, carriers pay attention. The spotlight is now on your safety records. If your FMCSA scores aren't clean, if you've got red flags in your CSA data, brokers who are paying attention are going to start avoiding giving you loads because if they hire you and something goes wrong, they're now legally exposed. This ruling puts pressure on everyone in the chain to actually care about who they're working with. Now, the manufacturing plant, you are not free and clear. Imagine if you hired a broker. That broker hired a carrier with a bad safety rating. Something happens on the road. That carrier is not only going to be suing that freight broker, but he's also going to add you, the manufacturing plant, in that lawsuit. Now let's talk specifically to the manufacturing plants and shippers watching this, because this is where it's really going to change. A lot of manufacturing companies move freight through freight brokers. You call a broker, they find a truck, the truck picks up your product, done. It feels simple, and for years it's been fine. But here's where the problem comes in. When you use a broker, you don't always know who's actually driving your freight. You don't know what that carrier's safety record looks like. You don't know if the driver has a prior incident. You're just trusting the freight broker to figure it all out. And now we know not all brokers are doing that due diligence. So if something goes wrong, if that truck gets into an accident, if someone gets hurt, and it comes out that the carrier had known safety problems, lawyers are going to trace that chain all the way back, and that chain might include you in it. Now, the ruling is specifically about brokers' liability, but here's the bigger picture. The more layers there are between you and the carrier, the less visibility you have, and the more exposed you are in a he said, she said legal situation that can drag out for years. So what should you do? Two things. Number one, if you're going to use a broker, vet them properly. Don't just go with whatever is the cheapest option out there. Ask them how they screen their carriers. Do they check the FMCSA safety ratings on a regular basis? Do they look at their CSA scores? Do they have a formal carrier onboarding process? If a broker can't answer those questions, walk away, because if something goes wrong, you want to be able to show that you did your homework, that you picked a broker who was actually serious about safety. Number two, and this is the bigger move, start building direct relationship with your carriers. Cut out the middleman where you can. When you work directly with a vetted carrier, you know who you're working with. You have a direct contract. You've reviewed their safety record yourself. You're not depending on a third party to do their job and hoping that they did it right. Direct carrier relations aren't just better legally, they're better operationally, better communication, better rates, better accountability, and now after this ruling, significantly less risk to you, the manufacturing plant. Look, brokers aren't going away, and they serve a real purpose, especially for spot freight or new lanes. But for your regular, reoccurring shipments, you should definitely know your carrier by name. The bottom line is this: the Supreme Court just told the entire freight industry that safety is everyone's responsibility, not just the carriers, not just the drivers. If you put an unsafe truck on the road or help put one there, you can be held accountable. That's actually a good thing for our industry, but it means the way a lot of the companies have been operating needs to change. Now, if you want to talk through what this means for your specific freight situation, how to vet carriers, how to build direct relationships, how to protect yourselves, reach out. This is exactly what we help companies figure out. Don't wait for a lawsuit to make you take this seriously. I'd love to hear some of your comments below on what you think. I'm Ronan, and I'll catch you in my next video.